On February 13th, 2017, two young girls, aged 13 and 14, Abby Williams and Libby German, went for a walk on the Monon High Bridge in Delphi, Indiana. That was the last time they were ever seen. Libby German uploaded a photo to Snapchat, well, two actually, one of the bridge and one of her friend Abby, and then she recorded a video of a man walking towards them, known in this case as Bridge Guy. Their bodies were found on February 14th, 2017, and for almost 6 years, no arrests were made. Eventually, in October 2022, Richard Allen was arrested, and he lived very close to the school that they went to Monon High Bridge, and he actually worked at the CVS pharmacy right there in the very small community of Delphi, Indiana. If you want a full deep dive and timeline, presentations, maps and everything, I'd highly recommend checking out my playlist, which I've linked for you in the description box on this case. Today is really a follow-up on the legal process that's happening as this case moves towards a trial for Richard Allen. If you have been following this case with me, you'll know that the last thing really was the probable cause affidavit. That was sealed for some time. It seemed to be a major topic of discussion, of course. Everyone wanted to know what was in it. And Richard Allen's attorneys were in favor of unsealing the probable cause affidavit. In today's document that we're going to look at here, you can see that now Richard Allen's attorneys actually are requesting to protect the discovery. Now, before I dive into this document, let me remind you that Richard Allen's hearing has been shifted. It was meant to be on March 17th, but it's now been moved. And the new dates will be June 15th and 16th. Richard Allen's attorneys are also asking that he be released on bail or on his own recognizance while awaiting for the trial because they say the evidence isn't strong enough against him. Of course, the prosecuting attorney, Nicholas McClelland, says the evidence is definitely strong enough and he should stay in jail. And right now, his bond is set to $20 million. So let's get into the latest documents in this case. State of Indiana versus Richard M. Allen. Order. Comes now the court, the State of Indiana, by Nicholas C. McClelland, prosecuting attorney, having filed its motion requesting protective order governing discovery, and the court being duly advised in the premises, now grants said motion, and the state, the defendant and counsel for the defendant, are now instructed and ordered as follows. That one copy of the discovery material shall be provided to counsel for the defendant, that no additional copies of the discovery material shall be made by the defendant's counsel, investigator, expert, or any other representative or agent of the defendant for any reason, that the discovery material shall not be used for any purpose other than to prepare for the defense in the above referenced cause number, that the discovery material shall not be publicly exhibited, displayed, shown, used for educational, research, or demonstrative purposes, or used in any other manner except in judicial proceedings in the above referenced action. that the discovery material may be viewed only by parties, counsel, and counsel's investigators and experts. That if copies of the discovery material are made and provided to the defendant, investigators, or experts for the defense, that sensitive and private information contained in the discovery shall be redacted, including any social security numbers, IDAC information, NCIC information, or any information related to the personal information of juveniles, including social security numbers, names, and date of birth, and any FBI Sentinel information. That none of the discovery material shall be divulged to any person not authorized to view the discovery material. This includes other witnesses, family members, relatives, and friends of the defendant. That no person other than the defendant, counsel for the defendant, and those persons listed in paragraph 5 shall be granted access to said discovery material or the substance of any portion thereof, unless that person has signed an agreement in writing that he or she has received a copy of this order and that he or she submits to the court's jurisdiction and authority with respect to the discovery, agrees to be subject to the court's contempt powers for any violation of this order, and is granted prior permission by this court to access said discovery. That upon final disposition of the case, the discovery material referred to in paragraph 1 and any and all transcripts shall be returned to the Carroll County Prosecutor's Office or maintained by the defense counsel pursuant to the terms herein. That counsel for the defendant shall be responsible to ensure that all persons involved in the defense of this case comply with this order. That the written documents or records provided by the state with the discovery material fall under the same rules as described above. This was so ordered on the 17th day of February 2023. On page 3 of 4, State of Indiana Plaintiff versus Richard M. Allen, Order or Judgment of the Court. Defendant with attorneys Bradley Rossi and Andrew Baldwin. State by prosecuting attorney Nicholas McClelland, with consent of the parties, hearing on defendant's motion to continue bail hearing and jury trial conducted via Zoom. Court grants the defendant's motion to continue bail hearing and resets the hearing to June 15 to 16, 2023 at 8:30 a.m. in the Carroll Circuit Court. Jury trial also continued to be reset at the bond or omni hearing June 15th, 2023. CR4 time chargeable to defendant. State's motion for protective order granted under separate order without objection by defendant. State's motion for protective order granted under separate order without objection by defendant. Media interveners, renewed motion to intervene and motion to grant public access to state's verified request to prohibit public access granted without hearing and without objection from the state and defendant under separate order. That was dated February 21st, 2023. State of Indiana versus Richard M. Allen. Defendant. Order granting media interveners renewed motion to intervene and motion to grant public access to the state's verified request to prohibit public access. The matter before the court is renewed motion to intervene and motion to grant public access to the state's verified request to prohibit public access filed by the media interveners, the motion. The court, having considered both motions and being duly advised, finds that the motion should be granted. It's therefore ordered, adjudged, and decreed that the media interveners are granted leave to intervene and the state's verified request to prohibit public access filed on October 28, 2022, shall be released to the public. The clerk is directed to make the verified request available to the public on the docket. That was dated 17th of February, 2023. Now, as always, let's look at an article for some layman's terms. Carroll County, Indiana. We now have some additional insight into the reasons Carroll County's prosecutor asked the judge to seal records in the Delphi murder case. Among other things, Carroll County prosecutor Nick McClelland argued that releasing the probable cause affidavit and other court documents related to Richard Allen would create serious and imminent danger to the public's interest and possibly damage an ongoing murder investigation. Allen is charged with 2 counts of murder in the deaths of Abby Williams and Libby German in February of 2017. Indiana State Police announced his arrest in October 2022, more than 5 years after their deaths. The probable cause affidavit was kept under seal after Allen's arrest, McClellan asked the court to shield it and other records from public view, a request approved by Judge Benjamin Diener, who later recused himself from the case in November. Special Judge Fran Goll of Allen County was then appointed to oversee the Delphi case. She authorized the release of a redacted version of the affidavit in November. In it, prosecutors said an unspent round found near the girls' bodies traced back to a gun owned by Allen. If you missed me reading through that entire probable cause affidavit and even talking about it with cop facts, and if you don't know who that is, it's all on the playlist for you. McClellan's original motion to have those records sealed, however, was not made available. Several media organizations filed a request to see the document, including Next Star Media Group, Fox 59, CBS 4's parent company. Goll ruled in favor of media interveners this week, making the record available to the public. The motion included 6 reasons McClellan wanted the probable cause affidavit and other court documents related to Allen kept under seal. They boiled down to protecting the public interest and preventing information from being released that could damage an ongoing murder investigation, although the motion didn't elaborate on the latter point. The state argued that the public interest will be secured by the sealing of the record, that dissemination of the information contained in the record will create serious and imminent danger to the public interest, that any prejudicial effect created by dissemination of the information cannot be avoided by any reasonable method other than the sealing of the record, that there is substantial probability that sealing of the record will be effective in protecting the public interest against the perceived danger, that the public interest will be substantially served by prohibiting access for the reason that the release of the information might damage an ongoing murder investigation, or that access or dissemination of the court record will create significant risk of substantial harm to the requester, other persons, or the general public. From the document. Further, the state is asking the court to find that remedial benefits to be gained by effectuating the public policy of the state are outweighed by the preponderance of the evidence for the above referenced reasons, and seal the records involved with this cause of action until further order of the court and for all other just and proper relief in the premises. In addition to making the previously sealed motion available, Goll granted a request this week from the state to protect discovery materials from public consumption. The judge's order stated that 1 copy of discovery material may be provided to Allen's defense attorneys and made available to any experts or investigators involved in building their client's defense case. No unauthorized parties may have access to that material, and it's incumbent upon the defense to comply with the order. Allen is next due in court for a bail hearing on June 15th. Goll set aside an additional June 16th date in case more discussion is required. A new trial date will be discussed during that time. Well, that is the quick update that I have for you today. Those are the latest documents that we have in this case that we've been following for quite some time now. Thank you so much to @thedocket71 on YouTube for getting those documents for us. You can go over there and subscribe to him. I will link his channel below as well. I'll keep you posted on any updates in this case as well as many others. As you know, I follow many cases very closely and I'm always looking for updates on what's happening so that I can bring that news to you guys. If you like this sort of short video, just reading a document or just keeping you updated on a case that you're interested in following, remember to subscribe, hit the bell so that you don't miss the next upload or live stream or whatever's happening here on Grizzly True Crime. And if you wouldn't mind, please like the video. If you like this sort of content, please share it as well. You can share it with the hashtag Delphi, hashtag Abby and Libby, or hashtag Justice for Abby and Libby. If you wouldn't mind also adding hashtag Grizzly True Crime or hashtag Gisela K, that would be much appreciated as well. Thank you so much for watching, and I will see you in the next one. Stay safe.